And regards to the parties, yesterday, one matter, both the party has request to fix the matter on Monday. But the other side council is come from mainland, so I have request to keep the matter in our top of the list, my lord, because they have come from mainland.
Let him come. It will be fixed on Monday.
It will fix, but if it is give some priority, then
Let him come. Let him come. Thereafter, we'll see.
otherwise it will be difficult. There's lots of matters there in Monday. I heard from the register.
You have mentioned it. I'll see into that.
Published.
Lordship, I have brought the supply code.
Okay.
This is an application for obtaining electricity connection in an encroachment area. My lord, there was an opposition which was filed by the opposite party. The respondent herein stating that the permit number has already been given a electricity connection. That was the claim by them, and apart from these, they have also stated that.
This one is the Jaya Prakash.
Yes, Lordship.
Jaya.
1 minute. So the electricity department is saying that it has been given in the name of Jaya Prakash, who resides
In the same
that-
building.
in the same building.
Yes.
So in the same building, there is no scope of giving another one connection. There is bar.
Encroached land, Lordship. It's for livelihood,
I'll
already one connection is
I'll
there.
come to that point later on.
Lordship.
In the same building, one connection has been given in the name of Jaya Prakash, and in the same building, another connection cannot be provided.
Yes.
That is your contention.
Yes.
Is there any bar?
There is no bar, but for livelihood we are providing. They are the encroachers of the government revenue land. They are not that they are the owner of the land.
Let them let him let us say let him
Lordship.
submit. Yes.
In the opposition, they have stated that if suppose a petitioner requires an electricity connection, she has to approach JERC.
Have you filed affidavit in reply?
Yes.
Where is the affidavit in reply?
This today morning only I have. In my reply, I have clearly.
Have you got the copy? Copy has been served.
Yes, just sometime before I have received.
1 minute. Till now, it is not tagged with the file. Let the affidavit in reply come. In the meantime, you submit.
My lord, that was the claim that according to the Joint Electricity Regulation Commission, she has to approach through that commission. My lord, now the JERC is very clear upon the occupancy. Like a petitioner requires to give their occupancy right. Like it is very clear in the JERC.
So, learned councils, there are 2 points. First point is, if there is bar, that cannot be provided.
There is no
To that effect, there is no bar
No bar.
in
No bar.
providing 2 connections in the same building.
Yes.
Now the contention is that whether she can be provided or not.
Lordship.
So
My lord, I just want to rely upon the judgment that was being passed by Justice Arindam Mukherjee. Sir. It was for the same note that the person requires to be in a settled position.
Does it deal with a separate issue apart from that,
That
which has been dealt with by the larger bench?
Larger
It
bench.
has relied in this judgment, larger bench has been relied,
Relied
everything
upon.
has been cleared, Lordship.
Has the copy been given to the other side?
Yes, yes, yes. Lordship, let it be on Monday, Lordship, let me go through one,
WPA 357 up to 2024.
Lordship,
Judgment dated 6th of September 2024.
Lordship.
Yes, let her submit.
Let her,
You will get the opportunity on Monday.
Lordship.
Yes.
My lordship, I just want to rely upon this judgment and the order will be passed.
What
by
was the fact? What was the fact
my
in that
lord,
one?
In the reply, I have clearly stated that.
What was the fact in the matter?
My
The
lord,
judgment of which you have cited.
My lord, here also petitioner claims electricity.
There are
connection in
difference of view, Lordship.
Well-
Another one judgment I will place on Monday, Lordship. Two different view of two judges of this honorable court. I will place that judgment also.
That was curtailed, my lord. because-
Not curtailed. How a single bench can set aside a order of the single bench?
Lord,
She has to make proper submission, Lordship, before the court.
My lord, they want to rely upon the judgment. Wherein WPA 194 of 2024, Santosh versus the superintendent engineer. That was the judgment they want to rely upon.
they want to rely.
They want to rely upon that particular case.
Do you have a copy of the said
My lord,
judgment?
just today, I don't have this copy, my lord. If it is fixed on Monday, I'll.
No, you provide the copy. Today itself. So I can go through.
Yes,
You are
Is it
relying,
possible?
you are going to rely upon the WPA, the judge.
I
passed
don't
in
know that
WPA.
number right now. I
Acha,
cannot
acha.
remember, Lordship.
Acha,
The
Then-
larger bench judgment is very clear upon the electricity connection, like.
But
the
thereafter,
GRC
after the
Doesn't.
Only
state-
one thing, only one request.
Lordship, I am sorry.
You will get the opportunity, she will get the opportunity. Yes. What were you
The
submitting?
GERC is very clear upon the term occupier,
Hmm.
consumer.
Hmm.
Now, this occupier is never been defined like legal or illegal. So the person who is in a settled position, that is very clear in the Abhimanyu's judgment. That is very clear. Upon that, my lord, I am just asking this relief. Because the act doesn't, the rules doesn't restrict anyone to get a second electricity connection. My lord, let my application be considered, my lord.
So according to you, in respect of a government revenue land, everybody is to be provided with connection.
An encroacher who is in a settled position can be provided with an electricity connection upon the larger bench.
You have just said that encroacher, whether he be legally settled or illegally,
Because the
shall have to be provided. It is
definition,
your contention.
my lord.
Place that portion.
GERC definition में clear बात है. Correct.
Yes.
Now the definition part, my lord.
Take. Definition. Which one you are relying upon?
The definition part K, consumer. Occupier, KK.
Definition is
The
two
definition.
point three.
GERC.
Which one is relying upon? Is not relying upon this one? Which one?
KK. My lord. Definition KK,
Then
occupier.
you have to provide.
My lord, I just have one problem.
No,
It will be there in that.
Occupier.
Learned counsel, it is your prayer, it is your petition. You will have to satisfy the court.
My lord, this is the only prayer which I would like to place before this honorable court that
No.
I am a petitioner who has encroached a government revenue land wherein I am in a settled position. In the reply, I have accepted, I have denied that I do not know this Jay Prakash and no one resides in the name of Jay Prakash in the said government number. That is there in my affidavit. It is very clearly been stated. My lord, I'm just leaving up to this honorable court to because various judgments are there, my lord.
Affidavit in reply has been provided to you?
Yes,
In which
Lordship.
paragraph?
Paragraph number 6.
This is JERC 2011-2010. Now it has been amended 2018 JERC regulation has
But
come
there
in
is
place.
definition.
Learned counsel,
My lord, there is
no, 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 no.
What
We
is
won't,
this?
we won't entertain that. The latest one will have to be provided.
Yes, 2018 I have provided.
If there is any changes in or amendment is there, no amendment is there, my lord.
The court, this court is least bothered about that. Whether there's changes or not, least bothered about that.
Sorry.
The latest one is to be provided. The court would hunt whether there's a change or not. You place paragraph 6.
My lord, that with reference to the countries made in para 3A of the petitioner not denied to the extent borne by records, but anything contrary or inconsistent thereof without denied and disproved. In reply to this opposition, the petitioner states herein that in the year 2016, when the petitioner encroached this government revenue license, this electricity connection is in the said landed property. Further, the petitioner says that she doesn't know any Jay Prakash and no one resides there in the said encroached property by the said name of Jay Prakash.
In reply to this opposition, the petitioner states herein that in the year 2016, when the petitioner encroached this government revenue land, since then this electric connection is in the said landed property. What is the meaning of this one?
The electricity connection was there in the said landed property, my lord, but she doesn't know who is Jay Prakash and no one resides in the name of Jay Prakash there. Connection was there, but she doesn't know who is Jay Prakash and no one resides in the name of Jay Prakash in the said landed property, my lord.
So there is, you are admitting the fact that there is electric connection.
Electricity connection, she also admits, my lord.
That means.
But
In the
she
name
has-
of Jai Prakash, they are claiming that it is in the name of Jai Prakash.
my
You are stating that there is nobody residing in the name of Jai
Jay
Prakash.
Prakash in the said landed property.
So you are being provided with the electricity supply.
My lord, I do not know who is Jay Prakash, my lord. It was a shed wherein a connection was provided, my lord. Now, she has made a development so that she cannot be curtailed with a note that she cannot be provided an electricity connection. She is not going to claim because she has made undertaking declaration that she will not claim the ownership upon the said land, my lord. That can be
We are not at all
appreciated.
concerned. We are concerned. What is the object of that? Object is to provide
Electricity connection
electricity supply of
in
supply
her
electricity
accommodation.
in the place where
She resides.
anybody resides. You are being provided with electricity.
My lord, no,
So-
it was not on my, it was not on my rented, I mean, tented place. My lord may say in the opposition.
Learned counsel, you have mentioned in your reply since the year 2016. In reply to this opposition, the petitioner states herein that in the year 2016, when the petitioner encroached this government revenue land, since then the electric connection is in the said landed property.
That's the
What does it mean?
That's the factual road. When she encroached this particular property, there
Achha.
was an
Let us
electricity
let us go through the petition now. Let us go to page 12. That is the undertaking. Annexure. Page 12, paragraph 4.
My lord,
What have you written?
that there is no any other electrical connection has been provided in the same encroachment land. My lord, that India is not being fenced, my lord. She is not aware whether that particular survey number belongs to this particular land or not. They are the layman, my lord, that should be considered.
Oh, hard to believe. each and every encroacher has a separate survey number? Has a separate survey number? So. And you are encroaching 150 square meters of land. What is we submitted further?
It's not my lord. It just proves the purpose of honorable court. Let my application be considered and electricity may be provided by that. Because I am no way connected with Jayaprakash and I would, he has also stated in her affidavit in reply that she doesn't know this Jayaprakash at all. And the,
It is not a vast area.
my lord,
One thing.
for the
First, respond to the query of the court. It is not a vast area. Is it a vast area?
150 square meter.
150 square meters. And in that site, there is an existing electric connection. So you cannot claim that it is beyond your knowledge.
She, in her reply, she has stated that she knows. My
She
lord,
knows.
Undertaking regarding this undertaking, one used to give an undertaking that no electric connection was given on my name in that particular survey. Being an encroacher, that's the undertaking. Only one connection can be provided in the name of an encroacher. So that's the undertaking they used to give in the form of this undertaking. Affidavit.
What do you want to rely? Place it. What do you want to rely?
That undertaking.
That
Page number first.
page
Page number 12, yes.
It is stated, my lord,
You
that,
place it.
page
Step
number-
by step, you place
page
your
number-
submission.
Page number 12. That para number 4, my lord. There is no any other electrical connection has been provided. This is the format they have given. My lord, according to the.
You have stated, it is your signature bearing, the document bearing your signature, wherein you have stated that there is no other electrical connection provided in the same enclosed land.
My lord. in the
So
name
is
of
it
the
correct?
petition-
Is it correct?
My lord, this.
Learned counsel,
My lord, my.
give response to the query of the court. Is that correct? So
My lord, the-
how can, if
Not
if-
in her name,
learned counsel,
not in her name. No,
you cannot add anything to this document.
my lord.
Can you add anything to the document?
Not it.
Not. So we'll have to take into consideration what is mentioned in the
This
document.
is the format they have provided, my lord. Which is.
If anything is written
that
which
cannot-
is not correct, you will undertake to write it. So if, from your declaration, verbatim what you have mentioned, that there is no other electrical connection provided in the same enclosed land. That means that there is no supply of electricity in your plot of land. But from the affidavit in opposition, it transpires that there is supply of electricity in the same RCC building, which you have also admitted that there is Since then, the electric connection is in the said landed property.
Denying that fact.
So from the from the petition, one statement is there, and the contrary statement reveals from the affidavit in reply. Can one be provided with the relief if he or she doesn't come in clean hand before the court?
This electricity,
Learned counsel, first of all, you replied to this query of the court.
the undertaking.
There is contrary statement.
My lord,
Do you agree or not? Do you admit or not?
my lord.
So
The only thing is that there is no electricity connection on my name to the said property. That was not made clear in that undertaking. my lord.
who else are residing there? In the said plot of land, except you?
She and her relatives. Because she is unmarried.
Relatives means? Then counsel, till this present moment, it is hard to accept.
My lord, this art doesn't curtails for second connection, my lord. That may be treated. That may be considered, my lord. No way they are going to hampered by this connections. They can remove it, they can disagree with. They are not provided with any such sort of notice, my lord. That can be considered, my lord. My application.
What is the prayer in the repetition? Is there any prayer to that effect?
Directing the responding authorities to act in accordance with the law, await in nature in matters do issue directing the respondent number 3 hearing about to provide electricity in the venue of the petitioner standing on the part of the land, bearing survey number 393 Bapi, measuring area 150 square meters situated at Patibasti village. The rest is
There is no such prayer also.
directing respondent number 3 for providing an electricity connection in favor of the petitioner. My lord.
Hmm. On which ground? Banking upon the ground that there is no supply of electricity. You have made the prayer relying upon the ground, relying upon the fact that there is no supply of electricity. It is so.
My lord.
Hmm? So what to be done? You cannot develop the facts
My
which
lord.
which you have mentioned in your affidavit.
My lord. Let my application be considered, my lord, because there is no bar in the rules, my lord, for second electricity connection, because they says that.
First of all, you have come with unclean hand. Can one be provided with the relief? One who does not come with clean hands, without clean hands? First of all. Second, after the disclosure of the fact by the respondents, you are admitting the same. And last of all, there's no prayer to that effect that let that connection be disconnected and a fresh one be provided.
That application, I just pray, will not face this particular application of the drawing. Because prayer is just directing an authorities to provide an.
This one is being rejected, learned council. Because one has to come in clean hand.
Why not? Because what she has stated, that was narrated, my lord.
Hmm?
What she has stated, that was being drafted by me, my lord, because she herself came and she herself, what has been stated to me, and
That it is a submission of your client on affidavit. You cannot develop on that.
my lord,
Hmm.
let a liberty may be given to amend this particular readings.
How can that be? Learned council, that cannot be. Hmm. Hmm. In thi- This situation cannot be developed by you. It is a submission, it is a fact mentioned on affidavit by the client. Hmm. 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 The present writ petition has been preferred by one Srimati Arati Mojumdar, seeking supply of electricity in her encroached in her RCC building, which is situated on an encroached piece of government revenue land, being part of survey number 393/P, measuring an area of 150 square meters, situated at Patsu Basti village, Sri Vijayapuram, Port Blair, Tehsil, South Andaman. Through the paragraph, to the said writ petition, she has prayed the following. That is to be laid down in italics. Full stop. The learned counsel representing the writ petitioner submits that the writ petitioner is an encroacher upon the specified government revenue land, and after constructing upon the said land in the year 2016, she has been residing in the said building since then, and has sought for supply of electricity Full stop. Paragraph. Supply which be provided to her. Full stop. Paragraph. Go from. From the road. The learned counsel. The learned counsel representing the respondents submits. Then per contra, the learned counsel representing the respondents submits that the petitioner has relied upon the fact that she be provided
October, I don't believe he will come back.
Let
Let
it
it be not today.
Let it be passed over at this present moment. It will be taken up after recess.
Lordship,
At
after
two-
recess, I have some urgent work.
That you say. You have personal problem, that you say. Learned counsel, just now you have obtained a judgment in your favor on that ground only.
Lordship, only 4 matters, remaining other 3 matters are there. Lordship. I have some personal difficulties. So,
Yet,
Lordship.
what is? On consent of both side, let the matter appear on 13th. Item 3 is wrongly. Monday. So, order the first.
Item 4, WPS government mail of Lordship, I am appearing for the respondent.
In this matter, I am for the petitioner, petition matter. You need electric connection for the government revenue land.
Hmm.
It is survey number, my lord, 25/P, my lord. Dolly Range village, my lord.
Survey number
Survey number
25 by P,
/P, my lord.
measuring an area of 100 square
100
meters,
square meter, my lord.
situated near post office,
Dolly,
Ganj village, Sri Vijayapuram, South Andaman district.
yes, my lord.
Learned counsel, anything?
Lordship, we have already rejected his application.
Why?
Lordship, because as per the JRC regulation 5.30, Lordship, clause 8,
Hmm.
he has to submit the identity card mandatory having the same address proof as election card or ration card he has to submit. He has
Yeah.
not submitted, so we have rejected.
Well, my lord, I submitted
And he has not filed that
Origin-
rejection copy before this honorable court.
filing
It
the
was rejected.
One minute,
rejected
one
on
minute.
19
Exact address of the-
1 minute, 1 minute.
exact address of the location, Aadhaar card, I have submitted the online copy of.
Aadhaar card is not the mandatory.
5.30, 5.30, clause 8. For bona fide consumers residing in JJ clusters. Learned counsel, what is the meaning?
Sorry.
What is the meaning of, while going through earlier, I was thinking, what is the meaning of JJ clusters?
Actually, I have to take instructor from the department.
Not necessary
Very
to
frankly,
other
answer.
document, exact proof of the Aadhaar card is enough, my lord.
You are referring to
That is the-
which one?
Clause 7,
Clause 7, an applicant who is not an owner but an occupier of the premises shall, along with any one of the documents listed at 1 to 6, copy of registered sale deed, he does not have. Registered general power of attorney, municipal panchayat tax receipt or demand notice or any other related document, letter of allotment, copy. Listed 1 to 6 above, also furnish a no objection certificate from owner of the premises. Which one?
Clause 8.
7 or
JJ
8?
cluster, JJ cluster or in other area with no specific municipal address, the licensee may accept either ration card or
Electoral identity card.
Mandatory.
Mandatorily having the same address as a proof of occupancy.
Yes, but
Ration card,
No, I'm the permanent resident of this island, my
Huh?
lord. But unnecessary documentation,
Learned counsel,
Aadhaar card is enough, my lord.
learn
My-
bit slowly, bit
but-
slowly.
Yeah.
I'm unable to get what you're submitting. Bit
No.
slowly.
I have a Aadhaar card, I'm filing
Yes.
the Aadhaar card, my lord.
Any
Exact address of the,
5.29, any of the following documents shall be considered as acceptable proof of identity if the applicant is an individual. Learned counsel, 5.29, last one. It does not bear the address. Aadhaar card bears the address.
Yes, sir.
Yes, sir.
So
But Lordship, as per clause 8, Lordship 5.0, 3, clause 8, Lordship, this is the mandatory document, Lordship, because they are the encroacher, Lordship. Lordship, let them, at least they can provide that thing, Lordship. We are ready to provide the electricity connection. Let them fulfill that thing. Or else let him challenge the rejection order, Lordship. He has not challenged the rejection order.
My lord, I have a ration card, election
But,
card, but not
one minute.
proper address. my lord.
1 minute. It has already been rejected.
Yes, Lordship.
That has been mentioned.
No,
No, online, I already rejected on the, I don't know the better. The 6 month,
online it is available, Lordship. I have
6 month-
also brought from online, not.
my
the
lord, 6
department has
month
provided.
have
I
been
not-
completed. I'm
Hmm.
filing the application. 6 months have been completed, madam, my lord.
On
But my
19th, Lordship. I have-
My client made,
19/6/2024.
Yes.
yes, you.
Yes, you have handed
application
over.
has been rejected.
Application-
On 20th/6/2024, his application is rejected. On 19th, he has applied, on 20th, it has been rejected.
Remark, submit either ration card or electoral identity card mandatorily, having the same address as a proof of occupancy of the premises only for the purpose of releasing electricity connection.
Yes.
It has been rejected on 19/6. And when have you filed?
20th.
Okay.
20th,
On
26, 2020.
20, rejected on 20th of June 2024. And when have you filed the writ
Very
petition?
Filed the 19/6/2024, my lord.
I repeat it.
Repetition.
You have filed on. Where is the date? 20th December 2024. That is after 6 months.
Yes, my lord.
You have made the application online or offline?
Online application, my lord.
You could make the application online and now you are saying after 6 months that I do not know
My lord,
whether it
my
has been
client-
rejected
my
or
client- my client
accepted.
Not aware of the online, my lord. Last thing, come to my chamber, I'm filing the writ petition. my
He could make an application online, Learned Counsel. These submissions are not at all acceptable.
lord.
There should be a
Basic need of the.
cogent ground of the submission.
Basic need of the electric connection, my lord.
Hmm?
Basic need, my lord, electric connection,
Need?
basic need of the electric connection, my lord. That my submission, my lord.
Learned Counsel,
Electric.
what
elec-
need, what need?
Electric.
Basic need
Basic
of-
need.
Basic need.
Yes, my lord. That I come to.
Yes, it is the basic necessity. And for that reason, there is basic criteria which are to be fulfilled.
No, I have
So-
a Aadhaar card and address proof of this island.
Learned Counsel, he has provided the Aadhaar card.
Lordship, it has already been rejected, Lordship. Let him apply a fresh. Because he has not challenged that rejection order, Lordship. If you could have challenged, Lordship, I could have given the concession that yes, Aadhaar card is there. It is already rejected. He has to challenge that. He has not challenged. He has filed the writ petition after 6 months also without this rejection order.
Hmm. The present petition has been filed by Srimati V. Savita, Kavitha, in respect of seeking fresh electrical, seeking for a new electrical connection. At which place? Connection in the enclosed government revenue land bearing survey number
Lordship, just not today, Lordship. I
Not
could not
today.
able to take the instruction.
Not.
I'm appearing for the writ petition.
Just not today.
Obliged.
In this matter only, he is appearing. In the other matters, he had sought for adjournment.
No, for Mr. Prakash Nij.
For
Whosoever, in 4 or 5 matters, he had sought for adjournment.
Correct.
On this can be taken up on Monday.
Yes.
Monday, on consent of both sides, let the matter be taken up on 13-1.
obliged.
Obliged.
Item 6, CO 41 of 20.
Yes,
Pardon, Your Lordship, I'm appearing on VC.
yes. Yes,
May I submit, Your Lordship?
yes,
Lordship, I am appearing on behalf of Mr. SN Kanungo, who is the respondent number 2.
Floor of Kanun, opposite party number 2,
Yes, Your Lordship.
who is for the petitioners?
Petitioners are not appearing from a long duration of time. On the in last circuit, Mr. Tapan Kumar Das, learned advocate, appeared for the petitioner and he said he is recusing
He is
himself for
retiring from this case as he is not getting any
any
information.
instruction from the petitioner said. So thereafter, this matter came for 2-3 times. The petitioners are not seem to be interested
Let
in the matter.
None is representing the petitioner. Let the matter appear before the next circuit bench.
Lordship, may I submit with a due permission?
Yes,
Lordship, on the last occasion, on the last circuit, Mr. Justice Udayakumar has already instructed that if the petitioner is not appearing and they are to instruct to appear, and Tapan Das has already retired. So, Lordship has instructed me to file an affidavit stating that we have already, the matter has been settled and we have withdrawn the money. So the matter will be infructuous. And it will be dismissed for non-prosecution. In the meantime, to file me for an affidavit. In the meantime, Lordship, I have filed an affidavit.
Lord Counsel, what you are submitting, that is not being reflected in the last order.
Lordship, the last order, it is the parent to appear that it's in the decree and now they have no intention, they are intentional. Yes,
As the petitioner is not being represented, the matter is not being taken up today. It is being placed before the next circuit bench.
Lordship, from last 1.5 years, they have been not been present and they're not taking the this matter.
It can be dismissed for default. They are not appearing for
I
last.
am taking up the matter for the first time.
My lord.
Lord
Yes,
Counsel, it cannot be dismissed. It not justifiable to dismiss.
From the last 1.5 years, they are not appearing and the matter is the decree holder, the award holder has already executed the money and they're not up, so that is, they're not appearing. They've already filed and not appearing. I humbly pray for dismissing for non-default.
Before the next circuit bench.
Obliged.
As none is representing the petitioner, let the matter come up for the next circuit. Yes,
Item 7, affirmative 8 of consideration.
We have solved we have affected the service affected,
on
Affidavit.
Suban Barla.
affidavit service filed.
Therefore, the petitioner pays for time necessary regarding the file affidavit service delivery. That is, the affidavit of service. The affidavit of service has been filed. Lord Counsel, where is the postal receipt?
It's there next. At page 3.
That is the track consignment.
GG.
not the-
Track.
Where is the postal receipt?
Forwarding letter and the track consignment.
Postal receipt,
This
receipt
is,
is also.
this is the
considered-
result of, this is the result of that tracking of the receipt.
Learned
It
counsel,
was having been sent.
Learned counsel, the court will compare the postal receipt along with the track consignment. The postal receipt is required.
I'll check the.
An affidavit of service has been filed. Let it be kept with the record.
It is, name of the parties are there, consignment number is there.
On perusal of the affidavit of service, it transpires that the postal receipt has not been annexed. Full stop. Paragraph. At this stage, the learned counsel representing the petitioner submits that he will file
My,
he will file the
my,
postal receipt through supplementary affidavit.
my.
Huh? Let the matter appear before the next circuit bench. Sorry. At 2 p. Password.
Item 9, FAP co-controlling.
Lord, I want to do this matter before my lord. Before my lord, please, I will.
Who is appearing for the respondent or respondent?
The entire exercise of preparation of paper book was done by department in terms of the order of the division bench. Usual notice has to be served to the department. I have been handed out with one copy of mine. So,
The respondent is only one respondent.
sole respondent,
This is Jogeshwar
Jageshwar.
Lal.
Yes.
Hmm. So. And this court is also eager to take up second appeal.
Because we civil lawyer hardly gets any judges where we can do this.
In the principal bench, I take up second appeal sitting in single bench.
My lord. Now, the record needs to be checked up by the service because usual notice in a appeal is always done by the department.
Learned counsels who are. Oh, okay. Was. Who are interested in
a recorded tenant.
Hmm.
I can't be a landlord tenant. I'm not a tenant and landlord. So tenant has to be considered in that sense, in this regulation.
So herein, the state is the ultimate landlord.
Absolutely. Ownership is vested with the government, state. Absolutely.
Each and everybody is a tenant under the state.
Absolutely. Absolutely. So not to see the regulation. If after the commencement of this regulation, any tenant is dispossessed of any land held by him otherwise than process of law, he may within 2 years from the date of such dispossession apply to Tahsildar for his reinstatement in such land. Then Lordship, the procedures prescribed under subsection 2 in inquiries.
So, Lord Counsel, in this instant list, you are the subtenant.
No. The plaintiff says, I'm an adjacent plot holder. I have occupied a part of the plaintiff's land. And he has approached the Tahsildar under this provision.
So this is a suit for encroachment.
Suit for eviction. My eviction.
Not encroachment.
No. Effect is one and same. Since I've encroached it, he wants my eviction.
So in respect of some piece of land.
Absolutely. Part of the land.
Contiguous landowners.
Absolutely.
Not owners, occupiers of
Yes,
land.
yes.
And in respect of some piece of land that.
Plaintiff says, I'm the owner. You being the contiguous plot holder, you have occupied a part of the land which is a suit land in the plain.
Has commission taken place?
It was taken place. There are several discrepancy anomalies. Trial court considered it.
Ultimately, the correct report has come up.
It has come up. The commissioner was subject to cross-examination. Several things were.
Thereafter, the report has been admitted.
It was accepted.
Accepted.
Yes. And if one of these regulation 204, I could have understand had it been a suit for declaration of title, then I can maintain a suit, even if there is this provision. Now, can you see regulation 204 once? Because this has to be done in presence of other side.
Yes.
But since my lord have it fallen from my lord, page 41 may kindly be seen. Page 41, my lord. Under chapter Roman 17, miscellaneous 204. No suit or other proceeding shall, unless otherwise expressly provided in this regulation, lie or be instituted in any civil court with respect of any matter arising under and provided for by this regulation. The plaintiff in the plaint has clearly said that he has approached the Tahsildar under 161, proceeding is pending, even then he filed the suit. Now, I could have understood under the regulation there is any provision for declaration of title.
Let them come.
My lord.
So you will have to file the requisites and in addition to that, serve upon the learned counsel.
But there would be one difficulty, the paper book which is meant for respondent, it's with the record. It will not grant liberty to take me so that I have to serve it. There's one more paper book in the record. The paper book for respondent is already, because registry prepared the paper book. It's for my lord as also for the respondent. It will not grant me liberty, I can take that paper book, I can serve the notice to the council. First attempt I'll make to the council. If he refuse, then I'll put the requisites to the registry.
No, I think it will be better. You file the requisites.
My lord.
That be sent
Through
to
registry.
through court, through registry, and in addition to that, you serve upon the learned counsel.
My,
Thereafter, let somebody appear.
then we can.
Thereafter,
Yes,
the paper
yes,
book will
yes,
be-
yes. My lord. Yes.
Appear on Tuesday.
Tuesday, let it come on Tuesday.
Tuesday.
Then SA4 of 2024. With SA5 of 2024.
Lordship, in item number 10, one opinion appears for the respondent and for the argument on item number 11. Lordship, due to some urgent personal work, we proceeded to mail and let it be appeared before the next circuit bench.
10 and 11, 10 and 11.
10 and 11.
In 11, you are the
11, I am the appellant, and in 10, I am the respondent.
Sudhir Chandra Das. You are representing Sudhir Chandra Das.
Lordship,
That's because you are representing the appellant in item number 11,
Yes.
Sudhir Chandra Das. Next circuit bench.
Next circuit.
Who is representing the appellant in respect of item number 10?
Anando Halar.
Ananda Haldar. Your senior is not, it won't be available. On the prayer of the learned counsel. No, the learned advocate representing the appellant in SF 5 of 2024 submits that was senior has some personal difficulty. As such, she seeks for the matter to be placed before the upcoming circuit bench. Let the matter appear before the next circuit bench.
Thank you.
And 12 SAT 4 of 2024 with SAT 5 of 2024.
Your worship, item number 12 and 13, your worship, my paper book is not ready, your worship. I require some more time to make the paper book ready. Let it be in the next circuit.
In item number 4, you are in both you are the appellant.
Yes, your worship, 12 and 13.
I'm the respondent.
Okay. When they involved?
Your worship, it relates to landed property. Your worship. The question did not be added, right? It's a continuous.
Cannot be taken up at all. Cannot be taken up at all. If
Actually, this is not the case of this code law. It's a fire. That is the problem.
circuit bench will be available here only.
It's true, but getting the documents, preparing the paper book, that is a difficult thing. Here, the registry has not been directed to prepare the paper book. We have been directed to prepare the paper book. That's why for collection of documents, it's taking some time.
The learned counsel representing the
Item 14.
Your Lordship, 14 also, Your Lordship, I am praying for time because what happened, they have filed an application under order 41 rule 27 for introduction of certain documents, Your Lordship. And can 3 of 2024, they have.
41 rule 27 will be taken up along with the appeal.
Yes, Your Lordship, but I have to file my objection. If you can.
Oh, you are not the appellant.
I am the appellant, they have filed. Other side
They
has
have filed.
Yes.
So I have to file my objection to that.
Formal objection is required to be
It's
filed.
not formal objection because they are introducing certain documents
Hmm.
to see that my claim for bona fide requirement is finished.
Hmm.
That type of documents they are producing. And authenticity, I have to check with my client and I have to file the opposition, Your Lordships. One more date. may be
Whether,
here, Your Lordship.
where those documents or that document, one or more,
Three documents, 3 to
Those-
4 documents are there.
where those documents not available with the,
Subsequent development, subsequent events. Like construction of a new house, education of the children, all those things.
for the appellant. The learned counsel.
But we'll start today because so that from Monday onwards it can. I'll just. May I start?
Yes. Is there any problem?
No problem is, Lordship, paper book is already been filed. I've been served with the copy. I've already served. But records, it's not available.
The paper book is here,
No, that's connection some other matter.
or some other matter.
There is no paper.
Paper book has been prepared by the appellant.
One thing can be done, but the issue is very narrow in compass.
No, accordingly, the appellant is directed to prepare paper book.
Yes, by an order dated
With
7
the-
September 2021.
No, 24th June 2022. According to the appellant is ready to prepare paperwork within a period of 4 weeks from that list the appeal in the, but thereafter.
What has happened?
Hmm.
The dispute is between wife and husband. There was a divorce proceeding before this court which went to up to Supreme Court. Their paper books were prepared.
Hmm.
Again, this matter relates to a publication made by the wife.
Hmm.
Because a divorce application was filed by husband.
Hmm.
It was at the first instance granted by a family court.
Hmm.
Appeal was prepared by wife before the High Court.
Hmm.
During this interim period,
Hmm.
as the wife was smacking that the husband is going to contract second marriage, a publication was made in the Daily Telegram as in the form of a caution notice that an appeal is pending before the High Court as against the decree of divorce. High Court reversed the decree of divorce. That matter went up to the Supreme Court. Supreme Court affirmed the order of the High Court. Thereby, the decree of divorce was recalled, was reversed. The husband, taking into account those two paper publications, which is in the form of a caution notice, filed a suit for damages, or arising of which this second appeal has come. The trial court dismissed the suit. The first appeal court reversed it, and certain amount has been imposed upon my client to be paid to the husband in the form of a damages. Since by those paper publications, the first appellate court held, it tarnished the image of husband. That's the point which is involved in the second appeal. The issue is very narrow in compass, I would say, Lordship. There are two questions being formulated by this division bench on by an order dated 7 September.
But ultimately, there is no order in this regard that whether paper book has been filed or not.
We are under the impression, Lordship, because those divorce matter which travelled up to Supreme Court, they were paper books. Same by same name, Ananta Ramchandra, Ramchandra Ananta, same. So
Even my staff was carrying a paper book. And I was thinking the paper book has been filed.
Which one do you have?
But I have also the same paper, which madam has. This pertains to the divorce proceeding. Divorce proceeding.
So what is the remedy now?
Maybe say one thing. If the lower court record has arrived, it can be dispensed with. Under the appellate side's preparation of paper book can be dispensed with. If both are agreeable.
I am ready.
Even I am
ready
ready.
with that.
So this is subject to what my lord says. On dispensing the preparation of paper book, my lord will allow us, we can proceed to the second appeal from Monday onwards.
In the meantime, it cannot be prepared.
That's exactly what my adverse side is saying.
How many days will it take? Because hearing won't take much time. Hearing won't take much time. It will take hearing.
It would all depend upon my adverse side, my lordship. I'm an appellant. Madam is enjoying the trial court, appellate court judgment.
That is the amount of money.
Money I've been saddled to pay. In the form of a damage.
That has not yet been paid.
Not yet been paid. So I've taken out this appeal, my lordship. Appeal has been admitted.
Can't it be prepared within 2 to 3 days?
It can be done, but not there are.
Tuesday fix karo.
Tuesday,
If possible hai. If possible, I will also assist him to provide whatever papers I have.
Yes.
We'll try.
Yes.
If all the parties are willing and eager, then
We are.
obviously it can be taken up.
Even my lord, if my lord considered my prayer for dispensation because a lower court record has arrived. It's a procedure thing, lordship preparation. And
Nowadays, not lower court.
I'm sorry, lordship. It's
Trial court.
Trial. I'm so sorry. I'm sorry. It's trial.
Make an attempt.
Well,
Make an attempt to prepare. If it is not, if it cannot be prepared, then
well,
we will see as to that. First of, the learned counsel representing the appellant submits that.
हाँ, जो मेरे पास में है, मेरे पास जरूर होना चाहिए। पेमेंट किया है तो होगा, ऐसा हम सोचते हैं। कभी-कभी हम appellate court में पेपर बनाते हैं। अगर
And seeks an accommodation till 13th of January to file the paper books. Let the matter appear on 14th.
well,
New matter, Your Lordship, this one. Item number 16.
All are new matters. All are of 24. New matters can be disposed of earlier.
Second appeal, Your Lordship, in any circumstances, it will take time. Here, the point relates to registration of sale agreement, and number of things are there. The questions which have been framed.
The learned counsel representing the appellant.
Item 17, estate bank of in agreement 17. Nobody records the bank from months now. You must be-
You are for the appellant.
Yes, yes.
Appellant.
Yes.
Learned advocate, take his name. The learned counsel representing the petitioner. Learned counsel, your name
102 of conformity. Learn from the petition.
Mr. Tulsi Lal is for the respondent in this matter. He is not feeling well, so he just went to the doctor. He's an aged person. He just prayed for not today,
Not today.
not today.
He's not aged, he's young. Who said he's aged?
Might be, but
19, 19, I am appearing for IUCN.
How much is his age?
he is not above 60. We call him as a young man, Manoj.
Thank you.
We call him as a young man. But still
So, not today,
That's not
that earlier one.
Your Lordship, I am appearing for respondent number 3,
Item number
19.
19.
Yes, I am for respondent number 3.
Respondent number 3. For the petitioner.
I'm there.
Acha.
I'm there.
And respect of the other respondents.
But Mr. Lal is appearing. It's for Union of India.
Union of India is, acha, Union of India. I think must be respondent number 1. Any instruction?
No, he prayed for not today.
Not today.
Just-
Not today,
Yeah.
on the ground of Mr. Lal. Not today.
WPA 297 of 2021.
Let one by one. Others will be not today.
Item 21.
Therefore, we respond in 3 minutes.
20 and 21, my senior office, let it be in the next circuit.
20 and 21. No.
21 and 22.
21 and 22.
Senior is appearing for the respondents. He is the
Not on one side. 1 minute.
Now 21.
21, 21.
Item 21.
21. You are for the appellant.
Petition.
We are for the
Petitioner, WPA. So.
Also, there is an appeal only because challenging the labor court order.
Acha. Labor tribunal.
Yes. Since there is no appeal section.
First court is the labor tribunal. First court is the labor tribunal. Against the order of the labor tribunal, come up before this. Before single bench.
Yes, because there is no appellate provision, so it comes to the single bench.
In case of CAT,
CAT, that is a difference because there labor tribunal only one judge is there to hear. But in CAT, there are member judges also.
Member
So
judges,
that's why it comes like
division bench.
division bench.
Which, in item number 21, her name be recorded, learned advocate, representing the petitioner, submits that her senior is ill, as such, prays for fixing the matter before the next circuit bench. Consider the submission, let the matter appear before the next circuit bench. And
Respondent.
then will be
Respondent.
recorded. Respondent.
For superintendent engineering.
22,
Item
you are
22, WPA 25.
same submission, next circuit bench. You are representing the
My senior senior Miss is representing the respondent.
Food Corporation of India,
Your Honor,
Food Corporation of India.
Your Lordship.
Same, next circuit bench.
Okay.
Item 23, WPA 276 of 2022.
Your Lordship, Mohammed Tabrez sir is appearing for the petitioner. I'm praying for let it be on Wednesday. Because he is out of station for his, he went to mainland for his medical treatment. Let it be on Wednesday.
23 and 24.
My lord, in item number 24, my lord, Vishal sir is appearing.
1 minute, one by one.
Those are
20.
connected matters, madam. 23 and 24 are connected matters.
No, he's appearing in 24 only, not in 23.
That is, because advocates are different.
On Wednesday.
No, let me, just say
Oh, he's appearing in both the matters, or one matter,
only,
24. So as they are related, they cannot be taken up.
Let it be next circuit, your
We have
lordship.
written to ministry certain clarification required from the ministry. So that will also going to require some time.
So, on consent of both sides,
Your lordship.
My consent is not required on prayers of the traditional so that it can go.
they are praying for, fixing it on Wednesday.
That is not the concept. No problem.
On consent of both sides, on consent of all the sides, let the matter appear before the next circuit bench.
Obliged.
Item 25, WPA 314 of 2022. Petitioner arising out of what was made. They have served.
Jivan Topo. Who is representing? Has it been served?
It has been served, my lord. The copy of service.
Affidavit of service has been filed.
I shall file an affidavit.
On Monday. It has been served. It has been served.
Track report shows it's delivered.
Delivered.
Affidavit of service has also been filed earlier. So that-
Filed.
In 2022 also it was filed.
2022.
22 it was filed, thereafter they were not appearing, thereafter again a service question was made, and then my lord, this affidavit has been served. So we shall file a fresh affidavit of service, no problem.
Item number.
Should be in item number 26, 27, and 28, same submission.
26, 27, 28. For the petitioners,
In all the three.
for the petitioners. 26, 27, 28. Next circuit bench.
But 26 and 28 we are for the respondent.
For 26 and 28, their presence be noted. 26 and 28. And for the 27,
Sumit Karnalkar, sir, is the parent.
Public prosecutor.
he is not available. So in 27 and 27 CRR.
CR. Learned PP is appearing in this party.
So 26, 27 and 28, all three for the next circuit bench. 26 and 28, their presence be noted.
Obliged.
Item 29, WPA 645 of 2023.
Actually, I could give sponsor for the petitioner. Council is busy in other court. I pray for next circuit because we have to file affidavit in
reply, but we couldn't find, so.
What is what is your submission? What is your submission, learned counsel?
We have to file affidavit in replies, but we couldn't find it.
Why?
Because the petitioner is at mainland for his treatment, we couldn't meet the.
What is the prayer now? Next circuit, next circuit.
The next circuit.
Before the next circuit.